about a clear statement rule, which seemed to suggest that some sort of verbal formulation is required. But what Castro says is that there has to be a clear indication of Congress's intent. So what Castro says is that we look to the intent and some clear indication of intent. Can't that indication of intent come from something other than specific words? Can it come from the structure?
Certainly. I mean, that's normal statutory construction. You determine the meaning of Congress through interpretation of the words and the context and surrounding provisions. And again, all of these are coming together, in our view, to point in our direction.
And do you think those structural arguments are policy arguments?
No, not at all. These are textual arguments. And, no one has come up with an answer. No one has come up with an answer to why Congress used particular text, second or successive application. In E, A, B, C, D, and E all use that broad language that naturally captures 2255 and 2254. Why did it do that? And then in B1 and B2 uses a very specific targeted language. Habeas corpus petition under Section 2254. That is, I think, almost fatal to any argument that either the amicus or petitioner has that would sweep out, either jurisdiction or sweep in B1. Now, I would say the amicus, if you take the amicus's reading, the amicus's reading would sweep in E anyway. We'd win on jurisdiction under the amicus's reading. But the text, there's just not been a textual explanation for Congress's deliberate use of this distinct language. That language, though, maps directly. The language is both the authorization language in B3, A through E, as well as 4, the authorization language and the broader use of successive, second or successive application, all of that directly maps onto a 2255, which is asking about the certification process in 2244. So when you add all of that together, we think there's a pretty strong and compelling textual reason to conclude that there's no jurisdiction here. And the idea that this is a dismissal, not a denial, I think is countertextual. And not only that, I think we really haven't gone into what Castro says, but Castro's holding is ultimately that the subject says the subject is not the denial of authorization, which would be the denial of authorization to file a second or successive. It is the lower court's refusal to recognize that the 2255 motion is his first, not his second. That, again, maps directly on the question of whether it's a second or successive under the jurisdictional provision that bars review of denials of second or successive. All that Castro, just like Villamonte Marquez or Stewart, if you call it that, all those two cases were deciding was that these cases aren't in the box of second or successive. The whole grant or denial thing is not relevant here. Therefore, there's no jurisdictional bar. If you were to start construing the cert bar to include, well, we're going to look to the reason. Maybe this applies and maybe that doesn't apply. You're creating a huge hole when Congress used broad language to say it's going to be any grant or denial of authorization.
Does it matter, Mr.